may recall the case I was talking about. In 2009, police were pursuing Stephen McDonald on Auckland's northwestern motorway. Stephen was high on drugs and was shooting willy-nilly at officers. Richard Neville, as we've said, sustained life-changing injuries after a stray bullet hit his windscreen. Another man, courier driver Naitata Naitoko, was also caught up in the crossfire that day. You'll remember what happened to him. He wasn't quite so lucky. He died. His family were paid a large sum. An inquiry found the shooting by police was inaccurate and unsafe. That's crucial. So Richard Neville's lawyers will argue this morning that he has a right to sue police for compensation and will take his case to the High Court. Canterbury University Head of Law, Dr Chris Gallavin, joins me now. Chris, good to have you with us.
Morning, Paul.
What is it that Neville's lawyers have to prove in court today?
Well, this is a striking out application by the Crown, Paul. So the Crown is saying the court's got no jurisdiction, and really the biggest impediment for his lawyers is trying to get around the ACC legislation, actually, because as far as compensation for injury is concerned, of course, we have ACC, and that provides a statute bar to these types of actions.
That's right. So you would think that that would be the natural course you would take in a case like this. You'd be going to ACC.
Yeah, and okay, even if he got ACC, and that's a matter privately, it's not a public record as to whether he's been on ACC. I'm sure that he has been. It's only 80%, of course, but the statute bar means you can't even apply for the top-up of the 20%. There is an exception to that with reparation with criminal cases, but that doesn't apply here. So, you know, an absolute tragedy for this man, everybody's worst nightmare for, as you said, minding your own business and being, you know, a bullet coming through the windscreen. But the real impediment here for his legal team is to say that ACC is not an impediment to this action going ahead.
Okay, so how much, I mean, at the end of the day, accidents happen, as I said, and that's what accident compensation is there for. But we have the IPCA, the Independent Police Complaints Authority, coming down and saying that police didn't break the law in this case, but their shooting was inaccurate and unsafe. Now, some might lead that to negligent. If they can prove negligence, then on that basis, wouldn't Neville have a case?
Yeah, well, even if he's unsuccessful as far as the ACC compensation issue is concerned, that doesn't necessarily mean it's the end of the case, because he might actually go for exemplary damages rather than compensation. So exemplary damages, if you think about that, is just really being a fine, that the police being fined for their negligence, if that can be proved. So two things today. One is that his legal team's going to have to, like I said, get around the ACC issue if he's going to be applying for compensation, quote unquote. But even if he's unsuccessful at that, then he's got to show that he has a cause of action in tort or something under a breach of the New Zealand Bill of Rights Act based on that issue of negligence, as you say. And then he could actually argue that the police ought to be effectively reprimanded by the court with an award of exemplary damages, which of course he would then say should be paid to him. Not compensation, though, if he is not successful with the ACC issue.
Yeah. Have police handled this well, do you think?
Well, it's been widely reported that they've made an offer of $5,000 in the context of his claim of $1.4 million. I can understand that he'd see that as a slap in the face.
My understanding, Chris, is that he took this case for $1.4 million. Police entered negotiations with him. He immediately dropped that back to $600,000, but has now reinstated that because they came at him with $5,000, which is a ludicrous amount, isn't it?
Yeah, look, on both sides it's without prejudice. So he's gone back to his base position of $1.4 million, even though he made the concession of $600,000, which he would have said that shows good faith and goodwill entering into those negotiations. And that $5,000 offer, if that's true, is not going to be held against the police. Again, it will be on a without prejudice basis. So it's all bets are off as far as today is concerned. But of course, his $1.4 million is based upon a compensation claim.
Which is an error, you think? Yeah.
Well, I think he's got a very, very tough road to hoe as far as getting around ACC legislation. If he's successful and he goes for exemplary damages, exemplary damages, that fine, reprimanding of the police by the court, then he's not looking at anything like $1.4 million.
Just finally, Chris, the one person we haven't talked about here is Stephen McDonald, without whom we wouldn't be talking about this at all, without whom Richard Neville would have not lost his hearing, would not be out of pocket, without whom the police would not be in the gun. Is there some way, because I mean he fits the causation criteria here, doesn't he?
Yeah, well, I actually wrote something for the New Zealand Herald, which they didn't publish, Paul, in 2009, which they should have. And I said that, and I said that McDonald should have been charged. I mean, there is precedent overseas, a little unusual, of course, but saying that the causation, he went on this rampage. It was foreseeable that actually that there would be effectively a shootout, or that the police, the armed defender squad, would be involved, and that I think that he should have actually been charged, A, with an assault of this gentleman, and B, with the death, the culpable homicide of the young Tongan man, I think he was, who tragically was killed by the police.
So would you be going manslaughter and assault, something like that?
Well, it could even be. It could have even been murder if they had the foresight, but manslaughter at the very least, and assault. But probably the horse is bolted as far as that is concerned. But the police, I think, or the Solicitor General, getting back to that issue,
dropped the ball again.
He should have actually, wasn't Mike Heron at the time, but he should have pursued charges against him for the actions, what might it look like by the police, but were really only a foreseeable result of the actions of McDonald.
Absolutely. Chris, thank you so much. Always good talking to you. Dr Chris Gallavin, Canterbury University law head.